Under the Bharatiya Sakshya Adhiniyam 2023, documents are broadly classified into public documents and private documents. This distinction is important because different rules apply regarding their proof in court. 1. Public document meaning a public document is a document prepared, maintained, or recorded by a public officer in the discharge of official duties, or a document forming part of the official records of the government, courts, public bodies, or public authorities. Simple meaning a public document is an official document created or kept by a government department or public authority for public purposes. Examples: court judgments and orders, birth and death registers, revenue records, government notifications, electoral rolls, records maintained by government offices, registration records of property. These documents are presumed to be genuine because they are prepared by public officials while performing official duties. 2. Private document meaning every document that is not a public document is a private document. Simple meaning a private document is a document prepared by private individuals and not by a public authority in the performance of official duties. Examples: agreements and contracts, private letters, personal diaries, business correspondence, promissory notes, receipts between private persons, private account books. Such documents must generally be proved by the person relying upon them. Difference between public and private documents. Basis: public document, private document. Prepared by government or public authority, private individuals. Nature: official record, personal or private record. Custody: public office, private custody. Presumption: greater authenticity must usually be proved. Example: court record, birth register, agreement, letter. Certified copies of public documents. Meaning of certified copy: a certified copy is a copy issued by the public officer having custody of the original document. The officer certifies that the copy is a true and accurate copy of the original. Admissibility in evidence. Yes. Certified copies of public documents are admissible in evidence. The law permits certified copies to be produced instead of the original public document because public records are required to remain in official custody and cannot be removed every time a case is filed. Reason: if courts required the original public records in every case, government offices would lose important records. Public administration would suffer. Judicial proceedings would become difficult and time-consuming. Therefore, certified copies are accepted as secondary evidence of public documents. Illustration: suppose a wants to prove ownership of land. Instead of bringing the original record from the office of the sub-registrar, produces a certified copy of the registered sale deed obtained from the concerned office. The certified copy is admissible in evidence because it is issued by the lawful custodian of the record. Simple case study. Ramesh files a suit claiming ownership of agricultural land. To prove his claim, he obtains a certified copy of the revenue record from the revenue department. The original record remains in government custody, but the certified copy is produced before the court. The court accepts the certified copy as admissible evidence because the revenue record is a public document. The copy is certified by the competent public officer. The law expressly allows certified copies of public documents to be used as evidence. Conclusion: a public document is an official document prepared or maintained by a public authority in the discharge of official duties, whereas a private document is any document created by private individuals. Public documents include court records, government registers, and official records, while contracts, letters, and private accounts are private documents. Certified copies of public documents are admissible in evidence because the law recognizes them as reliable copies issued by the lawful custodian.